It's like I'm living rent-free in your heads again, huh? I mean, if you're gonna spend your days obsessing over me, you might as well start calling me something respectable. Maybe Daddy Shizzy, or better yet, Papa Nut. Who's the grown-up here? Alright, it's me. Let's go. Call me Daddy, yeah, that's who I am. Running your mind's like a master plan. Papa Nut, Shizzy Daddy, take your pick. I'm owning in your thoughts while you still act sick. Call me Daddy, it's what you mean. While you chase the crust and I take the lead. Living rent-free, that's my name. Go ahead, say it, put some respect on the name. Man, I'm too old, well here's a surprise. I'm the one with the brains while you're stuck with the lies. You act like you're experts, but here's the reality. I'm the one controlling your mental reality. So while you're out there trying to throw shade, I'm sipping coffee and you're feeling betrayed. You're mad, I got the spotlight, now it's my time. So why not call me Daddy or Papa with a rhyme? I'm the landlord and you're just the tenants, stuck in your headspace with no end to sight, no repentance. Call me Daddy, you know it's true. You'd be lost without me, stuck in the glue. Call me Daddy, I'm owning your mind while you're scrambling, trying to find what's behind. Papa Nut, Shizzy Daddy, don't you see? You're living in my world now, I'm the VIP. Call me Daddy, just let it be. While you're trying to figure out your own identity. Oh, I see you're confused, trying to get it right, spinning your wheels while I'm out of sight. You think you've got it figured, but you got it all wrong. I've been running your minds all along. But sure, keep pretending you don't care. Keep saying you're done, but I'm still in the air. You got no choice but to bow to my name. Daddy Shizzy is here to own the game. You say you don't watch, but you're obsessed. Every word I say puts you to the test. Call me Daddy, Papa Nut, you know you should. Because I've been living rent-free, and you know it feels good. Stuck with Daddy for life. I'm Papa Nut, Shizzy Daddy, owning your headspace, and there's no escape. Good luck with that.
Of course, you would know that the audio isn't working. I had to look at that twice. I was like, man, audio's not working. Camera's not working. Nothing's working tonight. Oh, my. Hello, everyone. How are you doing this evening? Good to see you. Hello, hello. Hello, Richard Brick. How you doing? Elf, got Diane, got Round Band, Stacy Nat. Good to see ya. Man, Stacy, it is so really good to see you. I'm glad that you can make it over here. We've got M Spire, we got Heather May, we got Diane, Gaia Casa, New Mexico. Oh, wow, that's very cool. New Mexico. Good to see you. We got Heather May and Twaddle Bum. Oh my gosh, you guys are just piling on in. Jack Miles just sent a gift. Ooh, I like that. Let's see what that is. Ooh, he sent a high five. We got to share that thing because that's pretty cool. Let's share that with you guys. So yeah, we got a high five coming in right there. See right there, got the high five. Woohoo! I love it. Thank you very much. I appreciate it. Yeah, every single one of those I try to pay attention to. And then somebody put in flow state. What in the heck is that? Somebody, ooh, that's a member. Georgianne has become a member. Welcome to the Gathering Nuts, Georgia. Nice. I love it. I love it. Thank you very much. Thank you very much for joining in. It is absolutely wonderful to see you here. Yeah, you see me now. Well, and I can fix that really quick. See, I can hide like this, and I can come back, and I can hide again. Hey, Lisa, how you doing? Hey, Tree God, good to see you. Brenda Velasquez, good to see you. Frisbim, good evening. Yes, it is a Sunday. Man, it has been crazy busy. I've been working on updating thumbnails for like Sunday Spice. Because whenever I'm back in June, like starting in June, I hope to get back into doing some more of the Sunday Spice stuff. And what I wanted to show you is what I've been working on with that because it's really damn cool. I'm pretty happy with what I've gotten done with those. Like I created a whole new thumbnail for it because, it is a little bit spicy and, so I try to keep it, within the realm of, you know, sort of what we're actually doing on Sunday Spice. You miss Sunday Spice? Yeah, audio coffee. I miss it too, but I mean, there's just been so much going on, and most of the people that I was having to read with me, they've been just super busy also, and they're missing it too. But this right here is the thumbnail that I've been using for it right here. So this is the thumbnail. So if you see this thumbnail, you'll know that that's what Sunday Spice is right there. So it's got, a little bit of spice to it, a little spicy, let you know that's a little more adult oriented, not kid friendly, of course. So but yeah, that's that right there. You'll see those thumbnails come popping up. And if you want to catch up on some of those, you're always welcome to. Also, Deb in Michigan, good to see you. Welcome to the Gathering Nuts. And yes, I will play that song for everyone, whenever you become a new member. And if you're wondering what song that is, it is this one right here.
Welcome to the shit show.
Every Sunday.
Every single day.
Oh, every Monday.
A new flavor
Every Tuesday,
of
Wednesday,
fuckery.
Thursday,
Cause
Friday, Saturday,
everybody's such a
Sunday.
shitty and they're dumber
Oh,
than a bag of
but I
rocks.
appreciate all of you.
Monday, Tuesday,
Happy Sunday to you too, Alan Schaefer. Good to see you.
More days of
Yes.
increasingly stupid, ridiculous,
Ignorant boulder dash poppy cockball and vagary. Yes, it is. Ah, yes. Man, good to see all of you guys. Yes, this is a beautiful Sunday, and I was planning on doing a stream earlier, but I did want to spend a little time with my lovely wife. She was telling me that she was just like, oh, hey, you want to hang out for a little bit? And I was just like, yeah, let me finish this up. 45 minutes later, she was just like, I guess you're not showing. I was busy, but I managed to get it all done. Oh my gosh, Rosalind Duke also sent turn it up. She said to turn it up. What do you need turned up? Do you need it turned up or do you need it turned on? That's what I'm wondering. Rosalind, do you need it turned up or do you need it turned down? She said it. She said this nice little like turntables. I love it. I love it. That's awesome. That's very cool. Thank you very much, Rosalind. Oh my gosh. Yes, it is wonderful. Send a floating heart for 10 jewels. Thank you, Lisa Patterson. Oh my gosh, that is awesome. That is awesome. Thank you. I didn't see it come in here. I'm sure that it's showing up and there it is. There it is. Here we go. Sent sunshine, Debbie. 99 sent some sunshine. I love it. I forget that those I can hit a little heart right next to it. Appreciate you. Yeah. Ah. Well, where do we want to start with this? Where do we want to start with this? Yeah, I think the best thing to do is start with it in the only way that we really know how to do this. And you'll probably see there is a super tip thing that is up there. Yes, the super tips are turned on. I'm currently because I wanted to see if it would work. I'm currently running the OBS camera to see if I can get the super tips to work on it. If you're wondering what the super tips look like, I will show you exactly what they look like. So that way you have an idea. And this came in from KMAC Queen a little while ago. And this is what it says. There you go. See that right there is what happens whenever I do the super tips. Hopefully you guys can all hear that. You never know. You never know. And hopefully to all chat, it is flying by and may have missed saying hi to you. Yes, the chat does get absolutely crazy. I always switch it over to live chat so that way I can sort of keep up with every single one of you guys coming in. And also, yeah, that's very cool. That's very cool. You can't hear it. You couldn't hear it. Damn. see. The only problem with it, if I try to get you to hear it, okay, so the OBS, you can't hear the sound on it. Bet, I bet if I do this, you can hear it. But then you'll hear me echo. Right? Now you could hear it that time. You could hear it that time, but of course, and also, Rosalind Duke just sent some sunshine my way, sunshine on my shoulders. Did not hear it. Nope, didn't hear it that time either. I think I know what it might be. We'll have to see. We'll have to see what it actually is. Nope, nothing. Not again. I think I know what I can do to make that happen. Let me see. And I will try to give it a try. Let's see, create channel, and we'll say OBS Studio, and then we'll add it here in the stream mix. And let's see if it works this time. I will find out if it works really quick, and I'll do it one more time and see if it works. No, that is okay. I know what it is. I know what I need to do. I can remove that and can do it here. Add that to the mix. And what you'll probably hear it this time.
Music allowance, as they keep posting and keeping you so busy, need help.
Now, I know you guys heard it that time. No, nothing. If we were supposed to hear it, it went no sound. Nope. Sorry, nope. Can you hear it? No, we can't. I bet you did hear it. I would bet you did hear it that last time. It'll take a couple seconds. See. Are we going to suck it into too much of the Smoky Mountain this year? Yeah, I knew it would happen. But I have to. The only problem is it may happen on other spots too, which I don't want it to happen to. Okay, the fourth time is a charm. It's just like
Love your show, Shizzy.
me too. I heard it. Yeah, I figured you guys heard it. It was yeah, of course you heard Yamaha. I heard Professor Snape. Hey, gang, good to see you, Miss Peanut. Good to see you. Welcome. Now, I don't know if it'll work next time I shut it down. So if you hear it echoing and the super tips come in, I will make sure that I do what I'm supposed to do with it and mute that portion of it. So just, we'll see. Yamaha Biker, where are you? Yeah, I think they're messing with Yamaha again. That's what it seems to be to me, is that they're messing with him again, and I think we should all riot until we get Yamaha back. We should be pitchforks and torches at YouTube headquarters, and we need it. Thank you, Heather May. I appreciate it. All right, let's get this crazy stuff. Now, in case you're wondering, you got Doocy that's out there, and he seems to be a little bit upset that he's not getting the recognition that he wants for all of his fine work that he's been doing, by emailing the glory with emails, and he got really upset because he had somebody else write this for him, but this breathes of Doocy right here, because non-party dues special limited appearance motion to reopen case for limited purpose motion to vacate order granting motion to strike one authorized. It's just like, good Lord, couldn't you just shorten it down to non-party Bruce's Doocy's special limited appearance motion? There you go. Really simple, short, sweet, just like you. Deucey. Non-party deuce. Through underside counsel and appearance, specially. Well, I know about special. I've seen the special. Especially and solely for the limited purpose of challenging the order entered against him. Moves against under Florida Rule of Civil Procedure 1.540B4 to vacate the order granting motion to strike unauthorized communications and for sanctions for unauthorized practice of law. The order, to the extent necessary, Deuce also requests that the court reopen this closed case for the limited purpose of ruling on this motion. This motion is not filed on behalf of Lynette Preston. It's actually Lynette Preston, does not seek to reopen the merits of the closed action, does not constitute a general appearance by Mr. Deuce Manskin in the underlying case. Well, it says here that Manskin, he's through undersigned counsel and appearing specially and solely only for the limited purpose of challenging the order against him. Well, he moves under that Florida Rule of Civil Procedure 1.540B4 to vacate the order. He wants it vacated. Now, if you're wondering why he wants it vacated, or basically wants it voided out, okay, there's a simple reason why he wants that to be voided out. And the straight up point to all of that is he sort of missed his opportunity to respond to this. Okay. So this is whenever the order was first put in, that was back in December. Here we are, and 5 months later, sitting there going, well, why hasn't he filed anything before that? Well, and it's sort of one of those plays that an attorney will do, knowing that the case is stayed and nothing's sort of moving forward, sort of delay it off and then act like, oh, I never saw this, not my fault. Although he knew about this the whole time, it's pretty obvious he knew about this the whole time. From the rest of us, we can look at it and go, yeah, he knew about this, because he seemed to be pretty upset whenever this came out. So much so that the Connecticut bar actually found, yes, he has committed the act of unlicensed practice of law, and they're referring it to Connecticut State Bar to look over it. Now we've seen this because the judge did it, has retired, I bet. The judge that did it has retired. I don't know. BBB wants it voided. No. There's a reason why he actually wants to put it in as voided. Okay, and it's a legal loophole, I guess is the best way to put it. Is after a certain, you have up to a year to have a motion voided out of the system. Okay, so you're looking at it from the very beginning. Whenever you put it in, you have up to a year to actually file something that could void it out. But that's the only way that you could void it out, is you have to wait, like within that, you have to do it within that year's period of time. That's what he's trying to do, is just basically get the whole thing erased from it. And I mean, he does make some good arguments here. I will say that there are some good arguments, but I don't know if they're going to stand up to the scrutiny. And that most likely, and I don't know this for a fact, but I would most likely assume that Randy will probably file something in this also that's just that says, hey, he knew about this. He knew that he was doing bad. He was given proper service. I mean, that's the only reason he thinks that he might be able to get out of it, is because he wasn't given proper service. And there's like a line there where he's sort of he's crossing that whenever if you're familiar with the case, you understand that he's interjected himself into this case multiple times, which means he knows about the case and he's very well aware of the case. Get it out because DUI can use that in the case BBB filed. Oh, it's more than that, Big Bob. It's more than just DUI guy. It's also the Connecticut the Connecticut Grievance Committee has already ruled on this. They've referred it over. I don't know what's going on in Massachusetts. There's a possibility that they're looking into it also, because he's looking at losing his ability to practice law in any one of those states. They could easily strip him of his bar license or have heavy sanctions on him for doing that. And in the state of Florida, unlicensed practice of law, if which that's what the judge did, is referred it to the next people in line to look at it, which I believe is refers it to the Florida State Bar. The Florida State Bar produces that to the Florida Supreme Court, and once they send that to the Florida Supreme Court, the Florida Supreme Court can actually rule on it. Now, only thing that the judge did here is basically chastise and referred it to the Florida State Bar. So that's an important thing that you need to understand, most of all, because I mean, as we go through this whole thing, and although it says there's 51 pages, most of those are just exhibits, and those will go by super fast, because here's the thing. He filed a special limited appearance asking Levy County Court to reopen the closed case only long enough to rule on his motion to vacate the order that was entered against him. He's not appearing generally in the case and is not trying to reopen Preston's claims or the merits of the lawsuit. It's very limited on what he's asking. He's wanting them to vacate the order under Florida Rule of Civil Procedure 1.540B4, arguing that the order is void. His position is that he was a non-party, not counsel of record, was not admitted pro hoc vice, and had not appeared in the case when the order was entered. The motion says the order found he engaged in unauthorized practice of law, characterized that the conduct is a third-degree felony. Now, you have to understand they characterized it as a third-degree felony under Florida statutes. They struck the communications and all legal documents that are attributed to him. They admonished him, barred him from further communications with the court unless properly admitted, associated with the Florida Council, reserved jurisdiction to enforce the order. Now, his main argument, his biggest argument in this, is that they lack the authority to make a UPL determination because the Florida Supreme Court has exclusive constitutional authority over admission to the practice of law, attorney discipline, formal UPL determinations. And now what he's saying is that those issues are supposed to proceed through the Florida Bar Supreme Court processes, not by motion in a civil trial case. But he's also arguing that the court, they didn't have personal jurisdiction over him because he was never served with process, subpoenaed, joined as a party, or served with an order to show cause. Now he's saying that a private email from Randy Shockett attaching the motion hearing notice was not legally sufficient service. He's also going to claim that he was not given due process because the hearing notice did not certify service on him. He was not present. He wasn't represented. Order does not state he was given a chance to present evidence or respond. Also notes there was no transcript or recording of the hearing. And he basically wants the court to reopen the case for this limited issue, recognize his limited appearance, vacate the order, or alternatively remove the UPL felony sanctions, admonishment, injunction language, and leave only a neutral perspective directive. He's also asking the court to stay enforcement while the motion is pending and confirm that the court is making no finding that he committed UPL or any criminal offense. The only thing is he did all of those things. Every bit about it. Because what he's doing is he's acting like the judge held a criminal trial and convicted him of unauthorized practice of law, which is not what the judge did. Because it wasn't a criminal conviction. It was a case management and court protection order based on his conduct that occurred inside the case. Okay? So that if that helps you understand a little bit about where he was in this case. I mean, we all can have our opinions on where he was and what we're looking at. But as far as what the record shows, his behavior is completely different than the way he's trying to characterize it. So he's basically saying that he's not he's licensed to practice law, Connecticut, Massachusetts, and all of the stuff I already told you. The action was filed by Lynette against Jeremy Hales, George Foreman, DJ Radis, and Deuce was not a party, was not counsel of record, and had not appeared. Actually, I would say that according to Scott Stark's deposition, that's going to be a hard hill for him to climb up. Really hard hill for him to get over, because even in Scott Stark's deposition, Scott Stark noted that Deuce was telling that he was going to write motions for Lynette, and that he was going to send them on to him, and then he'd do all the grunt work. This is typical Deuce. He's done this stuff before in other cases where he doesn't want to be seen, because he would be like held liable if something screwed up, and he sort of has somebody else fall on the sword for it, which can put a lot of stress. And I mean, if I were here's the thing, if I were an attorney, I wouldn't want somebody else writing my motions unless I was just that crappy of an attorney. I would not want somebody else writing my motions because they think that they're better at it than I am. I would prefer to do the work myself. Or what kind of good am I at that? Did I see a photo of what? You guys are flying past me. Do you see a photo of DJ Russ and Luthman's stepmom? Stepmom. Okay. I don't know. I don't know. I see all kinds of stuff. They're weird on the internet. Maybe. Now, in October of 2023, Hales, through Randy Shockett, filed a motion to strike the unauthorized communications for sanctions. The motion alleged that Deuce is an out-of-state attorney. Well, I mean, are you saying that you're not? An out-of-state attorney, not licensed in Florida, not admitted pro hoc vice, and they had sent emails to the court and parties and have prepared legal documents filed in this matter. The motion sought relief regarding Deuce, including striking communications and legal documents attributed to him, prohibiting further communications with the court and parties, and referring the matter to the Florida bar. Well, that's sort of a brief summary of it, but there was quite a bit more going on with that. There was quite a bit more going on with it than just that, because he was also in very close communication with Lynette, and that can be proven in court by her own words, because and that might be why she's trying to avoid having to do this deposition that's going to be coming up, because then she will be on oath for everything that she's saying. Crazy enough, isn't it? Now, the motion did not join Deuce as a party. No, he sort of joined himself as a party. All you have to do is go look back whenever Scott Stark was supposed to be showing up for the deposition. He made sure that he was showing up also, because he wanted to know what Scott Stark was saying, so he knew what kind of defense to put forward whenever he got his ass handed to him for doing exactly what he did. You lurk away, Aaron. It's absolutely fine. Now, the motion did not join Deuce's party, request summons, seek an order to show cause, initiate contempt proceedings. Well, that's because the court didn't hold you in contempt. What the court did is they received emails from Deuce. Okay, there was no reason for them to find him in contempt. All they had was these emails that this guy is sending and arguing case law with him. And you notice that after that stuff got filed, he sort of backed off whenever that all got shown, because it would be one thing if he was copying Randy on it, because then Randy could have said, hey, you're not able to practice law in the state of Florida. Randy made no threats towards him. So, Randy was just like, yeah, I mean, here's what's going on. Randy, as far as I know, didn't know anything about these until the judge produced them. And that was just like, oh, yeah, you're not supposed to do that. And Deuce already knows he's not supposed to do that, because I can't think of a single state anywhere where they appreciate you sending emails to the court telling them how to questioning the judge's authority. I mean, even the judges have it listed on their websites, for like the Eighth Circuit, crap like that says, hey, personal emails to the judge will not be responded to. If you're trying to argue a case through email, you have to go through the proper channels, and that's not what Deuce did. He was trying to try the case with the judge. He had to pop out. Welcome back. Welcome back. Welcome back. Now, the motion did not join him to the. Oh, shit, I went too far. Let's see. I hate when it does that. The motion did not join Deuce as a party, request to summons, seek an order to show cause, or initiate contempt proceedings, nor did it identify any procedure by which he could appear and be heard. The motion further certified that the conferral was unnecessary because the matter involved a non-party. Well, and that's true. That's true. There wouldn't need to be any conferral in this because he's a non-party. And I would think that the judge just trying to get control of his courtroom would be one of the most important parts, because a judge doesn't want to have his staff having somebody email them constantly about something that they're not even a party to the case. I mean, think about this. How do you think it would be if every single person, and trust me, I'm not calling on anyone to do this, but how frustrated would it be for court staff, one person, maybe two, if every single supporter for Jeremy Hales were to email the judge? It would be so burdensome and cumbersome that they would get a little bit aggravated and either strike all of that or start tracking these people down and coming after them to do, to make sure that they were sanctioned, because that's court resources where they can be spending it on other things and trying to push things through. So yeah, doing that kind of stuff. And this is why it's always highly suggested, stay out of what you are not part of. But that's not what Deuce did. And he knows this as an attorney, he's not supposed to do it. The motion did not join him as a party. And because the matter involved a non-party, the legal standard. Ooh, here we get down to the legal standard. It authorizes a relief from judgment, decree, order proceeding when a judgment, decree, or order is voided. The rule applies to order as well as final judgments. Well, yeah, in 2016, but there's also other issues that you really didn't do that. An order is void when the court lacks subject matter jurisdiction. A void order may be challenged at any time and need not be supported by excusable neglect, meritorious defense, or due diligence, which is true. I mean, so then that's what I was telling you earlier, that a void order can be challenged at any time and need not be supported by neglect, meritorious defense, or anything like that. This is what I was telling you earlier. Now, limited reopening is appropriate, which he's correct. So the court can address an order entered against a non-party. The fact that the case is closed, the case is closed, but it hasn't been adjudicated. So like it's on stay right now. So the case really, it is closed, but not really. And he also seeks limited reopening to challenge an order that operates directly against him, has not been used in a separate disciplinary grievance, has not been used and has been used in a separate disciplinary grievance. Well, here's where he runs into it, and this is why he wants to get the order voided. He thinks that having the order voided eliminates him from in a certain way it does. It would eliminate him from having to answer any of those really hard questions in Connecticut, in Florida, and also in Massachusetts. He would be, see, right now he's looking at some severe sanctions for his behavior. And you can't blame him if you made a really bad boo-boo as an attorney and you're about to lose your livelihood. You would do everything that you could to fight against it. Whether you agree that, well, you shouldn't have just done the bad behavior in the first place, that would be something you might want to consider. That really might be something that you consider when everybody is telling you, stop. And the thing is he already knew that he was going to be doing this, that he was going to be filing things. He's going to be working behind the scenes. We've already seen all of the streams where he said that. We've got all of the documentation on this. And it's easily provable that he has already done this. Not just in this case, but also in other cases, working behind the scenes to help out the case. And what'll happen is eventually this will all catch up with him. And the judge, he could come back and say, hey, we'll go ahead and narrow this down, but we're still referring it to the Florida State Bar for your shenanigans. And that right there would, because the reason why they wrote the order that they did is you have to make a finding whenever something like this happens, whenever something that is so egregious like this happens. Welcome, Shirley. Good to see you. The reason that something like this happens and a judge writes an order like that is because they have to make a finding to know how to get control of their court docket so they can actually handle it. See, you have to remember that these guys have been running roughshod through all these court cases and prolonging as much of this as they possibly can, trying to cost Jeremy extreme amounts of money, having to fight against, like a multi-tiered attack. Because not only do you have Deuce that was attacking him. You got multiple YouTube channels that are trying to take down his businesses. You got multiple people that are associated with them that are false flagging, reporting, going after his businesses, and it just goes on and on and on. Yo, traveling fools, good to see you, brother. So you've got all these different levels of people that are attacking him and costing him money. And, just as Deuce said, he is trying to destroy Jeremy's YouTube empire because, nothing like a little jealousy. Just because you don't like somebody, well, here's a novel idea. It really sucks to hear this, Deuce, but all you have to do is just change the channel. Guess what? They're not talking about it anymore. They've gone away. It works really well. It worked just as well in the 50s and 40s and 30s, 20s as it does, in the 20s again. It's been very capable to not listen to what you don't want to listen to. But that he can't handle that right there. Now, the court lacks subject matter jurisdiction against the orders against Deuce because, well, they submits the order that is void for lack of subject matter jurisdiction. The effect arises from two related but independently sufficient grounds. First, Article 5, Section 15 of the Florida Constitution vests in the Florida Supreme Court the exclusive authority to determine, well, and see, this is the problem with the way that he has all of this worded. This little section right here is sort of important because this is the basis behind all of it. Okay, the basis behind having that UPL. Now, what he's saying is, in this right here, he's trying to say that it should be absolutely voided out. This is limited appearance, and that there was no reason for him to do any of this. Like for the judge to actually put it on him of not following the law, because they're saying, well, the judge had no way of dealing with this at all, and this is absolutely horrible. The only problem about this is the court didn't conduct a formal UPL prosecution. What the court did is they identified conduct was occurring inside its own case. They found that the conduct crossed into unauthorized practice of law. They struck all of that stuff. They restricted further communications and recognized the issue as referable to the proper authority. The court had to make some threshold finding. They had to make a threshold finding on the rule on the motion before they did that. They weren't issuing a statewide discipline or imposing a criminal sentence. What it was doing is it was deciding whether the communications in its own case was unauthorized. And I think that's where he's going to get hammered really hard on it. Because, him, and all of this right here, he's screaming about, well, you can't do this because, it says that the Supreme Court has exclusive jurisdiction. But you have to understand that they had to actually review it and see the misconduct to actually have a finding of why this stuff should be stricken. And this is, so whenever he's sitting there going, well, and all this is just right here. It's just what the statutes are, that the Florida Supreme Court has all of the ability to do it. So he spends, multiple pages going over this right here. Trust me. And he's getting absolutely like pissy about it. And they establishes that even when UPL question rises in civil litigation between actual parties, the circuit court may not resolve it in the first instant because the circuit, and that's the thing, is they didn't resolve it, but they have to make a finding of what the bad behavior is so they can make the referral. It's like, well, only a federal court can try a person for murder. And you arrested me for murder. There's no way that you can do that because, then you're telling me that you found me guilty of murder. That's what he's trying to argue here. This is his argument. If that makes sense to you, thank you. I appreciate it. Because I'm trying to clear this up a little bit so people can understand that in what he's saying is it entered an affirmative finding that he was guilty. No, it didn't say that he was guilty of it. What they said is this right here will be referred to the Florida State Bar. We found that unlicensed practice of law is this is what unlicensed practice of law is. It's just like if you delete somebody, that's what that is. If you break into somebody's house, that's breaking and entering. And that's what we're arresting you for. We're not trying you on it. We're referring it to somebody else. We're just basically trying to get control of our docket, of our court, which you have no control over. And that wasn't a guilt adjudication. They never found him guilty. They sent and referred it to the Florida Supreme Court for them to make the final ruling on it. Now they can look at it and say, hey, no, he absolutely did nothing wrong in this whatsoever. But you have to meet a threshold to actually get it there. No. So yeah, this guy's such a fool. No one has held him accountable for his previous BS. Now he's scared about time. Shizzy, you made good sense with the murder comparison since BB is trying to murder his own career. Well, I hope he's not trying to, because I think at one point in time, Bruce was probably a pretty damn good lawyer. But it seems like he might have gotten lazy or, ran into too many brick walls or something. I don't know, but something's not quite right with the guy's head lately. It's like, and so he's arguing cases that are just like, why are you even involved in this? And it seems like I think he thought he was going to be bigger than what he was. And, that really hurts his little fifis. That's what it seems to me, that he might just be upset that, he never became the lawyer that he thinks himself to be. And it's a harsh reality, but that does happen. I mean, think about this. I'm a musician, and you know, I was pretty good. I think I wasn't like horrible. I didn't suck. I mean, I held a pretty good spot in the band I played with. But also at some certain point, you realize that it's not going to happen. You're not going to get the big tours. You're not going to get the, multi-million dollar contracts. You're not going to be selling, platinum albums or anything like that. That's not going to happen. None of that stuff is going to happen. It's going to, and you're also getting older, and you got to, sort of think about your future. It's like it hasn't happened by now. It's probably not going to happen. And you realize that, and you shift gears and find something better. I don't think Bruce found that. I don't think Bruce found that position at any point in time. Out of state lawyers are not admitted no shit, are treated as non-lawyers for Florida regulatory purposes, are subject to the Supreme Court's Chapter 10 process, not circuit court sanctions. Well, that's the thing is from what I read in the order, they can actually sanction you for it, especially because you were, hey Gwen, how you doing? Because you were in the case. You were acting as an attorney. So they could find quite a bit about you that was wrong. And it looks to me like all they did is they referred you to the Florida State Bar for unlicensed practice of law. I have to pull that particular one up. Give me just a second. I'll actually pull that one up and take a look at it, because I'm pretty sure that I looked at that earlier today, and we will double check. I could be wrong, could be absolutely wrong, but I'm pretty sure that he sort of got his little butt hurt on that one pretty bad. There, and I believe it was, nope, that's the wrong case. Look at thumbnail. I believe it was document 103. I believe that's the one I was looking at. Yeah, here it is. Yeah, I thought I had it right here. So what it says is that the court finds that he is not licensed to practice law in Florida and has not been admitted pro hoc vice. So that's a finding. They also find that he's engaged in unlicensed practice in communications with the court parties in this case, including emails on these dates, which constitutes unauthorized practice of law, third-degree felony, referable, right here. That's all it says. Referable for prosecution to the Florida Supreme Court. That's all it is. That's all that the judge can do is refer it to the Florida Supreme Court. And all communications, including emails, legal documents, are stricken. He's admonished for engaging in the unauthorized practice of law without, and that's all it does is it admonishes him for engaging in the unauthorized practice of law in Florida without proper admission to the Florida bar or pro hoc vice, and he's enjoined from further communications. Nowhere in here does it say that he's being tried. It says he's being admonished. I guess a little spanking doesn't work on Bruce. That works on Paint Chip, but it doesn't work on Bruce. I think Paint Chip likes a good little spanking every so often. Just keeps him on his toes. So their decision amendments regarding court by advertising, also adopting. See, this is the only problem is they're arguing things here that the court didn't do. So that they're more than likely the judge will narrow this down. Make you sure you're live in chat so you don't miss anything. Also, I know that I've got you fine people that are over on the Rumble, and this is how Daddy pays his bills. He has to do one of these ads every so often. So if it shows up, and sometimes it takes a couple of seconds for the Rumble to show up and give me a nice little look see and make sure that it actually is going to work, but I don't think it will. Yeah, it doesn't seem like the live reads are working. There we go. Now it's working. It's working beautifully, because I can actually do these ad reads, which are pretty damn neat. And I hope you guys don't mind, but we're going to do a nice little ad read right about here. It is, if you still haven't tried 1775 coffee, now is your shot. The 1775 starter kit just dropped only 1,000 units. You're getting the bold, dark roast that hits hard, the smooth, medium roast, the vitality mushroom coffee for clean energy, laser focus with no crash, all single origin, small batch, toxin free, mold free. Very important. Don't want the mold. And you're also going to get that gold spoon clip, because freedom isn't scooped with plastic. No, sirree, it is scooped with a gold spoon clip. A frother that is also strong enough to stir up your coffee, and it might just stir up your mother-in-law's opinions, going, this is some really good coffee, and I like your frother. Now, a black 1775 tumbler is also going to come with this. Now, it's $170 worth of coffee and gear, yours for just that low price of $99. And this is for the ones who've been watching 1775 blow up on Rumble, wondering if it's actually worth it. And the spoiler alert, baby, sweet cheeks, it is. And go to 1775coffee.com/studio. Grab your starter kit before they're gone. They're bold beans, they're clean fuel, and morning routine that stands for something just like the Rumble does. Yes, sir. Yeah, that's some good stuff. We like it a coffee. We like it a coffee. Do a good read of those ads. You pay those bills. Sometimes you just have to. Sometimes you just have to pay the bills a little bit. I don't make a whole lot of money on YouTube. I'm not making that. How much was it? I'm trying to think. What did the fleas try to say that she didn't make? I don't make that kind of money. Of course, I don't use a child to raise money. It's sort of creepy. Now, the order went beyond permissible case management into territory reserved for the Florida Supreme Court. That's not true. I mean, that right there is just an out and out lie. He acknowledges that a circuit court has inherent authority to manage its own docket, regulate filings, decline to consider submissions from persons not properly before it, and refer matters of concern to the Florida bar. And that's what they did. That's exactly what the court did. Those measures as appropriate exercises circuit court's authority over its own proceedings. The order here went beyond those measures. So he's trying to claim that they overstepped their bounds. It finds that MadScan engaged in authorized practice of law. No. That's not what it says. Damn it. Do I have to pull this back up again? Right here. It says that he is engaged in communications with the courts and parties, in this case, including emails, and those constitute the unauthorized practice of law. That make a sec? No, I don't have a discount code. I wish I did. It makes the big bucks off of this. Yeah, like 92 cents. 92 cents is what I make. Like that. I don't even think. No, it's 41 cents, which is awesome. Yeah, 41 cents. Including emails dated October 6th, 2025, October 7th, 2025, October 9th, 2025. I mean, these are facts. This isn't like them trying him for it. That's them saying that this is referable for prosecution in the Florida Supreme Court. That's it. It's like, this is what they arrested him for. 20,000. Man, you realize that if you're making $20,000 a month off of YouTube, just off of YouTube, We're not talking about super chats or anything like that. If you're making $20,000 a month just off of YouTube, you're probably looking at someone that has multi-millions worth of subscribers. Okay. 10,000 subs is not going to make you $20,000 off of YouTube. Now, if Tug is making that kind of money, he's making that money through not only super chats, but any sort of endorsements that he does, any sort of money that is sent to him, and memberships. Just you don't realize you're not going to be pulling in 20 grand a month. This is a big thought that a lot of people have. You watch your nickels and dimes, Shizzy, is the dollars will take care of themselves. That's right. The dollars always do take care of themselves every single time. I just do me. Makes it so much easier. Yeah, that's what they said right here. They're saying that in this case, that those communications constitute the unauthorized practice of law. It's a third-degree felony, and they referred it to the Florida Supreme Court. What they're trying to argue here is that the order went well beyond the measures. It finds that he engaged in unauthorized practice of law, characterized that conduct. Well, that it is, because that's what that conduct is. It's a third-degree felony under the Section 454 Florida statutes. Personally admonishes him, yes. Strikes all communication of legal documents attributed to him, yes. Enjoins his future communications with the court and reserves the enforcement jurisdiction against him, yes. They're saying that each of these provisions operates directly and personally against dues by name, yes. Taken together, they constitute a UPL guilt adjudication. No. That's a misrepresentation. Taken together, they do not constitute a UPL adjudication with punitive and injunctive consequences. No. They don't. You're wrong. Attorneys, you're wrong. That's not what it does. And the judge, this right here is probably one of the most important lines, to trying to say that this right here is that those are the same. They're trying to say that those are the same, and they're not. Nowhere close are they this. Nowhere even close are they the same thing. So much ridiculous. So much ridiculous right here. Uniformly describes the province of Florida Supreme Court acted on a Florida bar position. Now, well, why don't we do this? And let's see if I can. I'm gonna have to do something really quick here. Give me just a second. And it's not your fault. I'm just trying to get this thing to scan this out, and so that way I can copy the actual language from it and pull this up for you, because that is going to be what we are looking at right here. And it always has to. It usually takes a couple of seconds for it to go through and look and find all of the actual language that I need. It has to go through all the exhibits, and once it gets through all of those, then I can go back. And it's just boring stuff that you don't want to see. It's doing like a scan through the whole thing. And once it completes its scan and finds all of the actual lettering in it, then I can do a copy of the exact wording in this and look up that particular case, because that is going to be what's really important, is this particular case that they're talking about, and we'll see if it actually applies to it. Because if it applies to it, then they might have some sort of, I could, like I said, I could be absolutely wrong in this. Let's see. So let's look up what the hell? Damn it. It didn't do it because it was scanned in. All right. This is easy to remedy. And I would put up some squirt dump up there for you just to make you fun. Let's see. Let's look at Luke. Lugo, Rodriguez, Ludo dash Rodriguez, R-O-D, Rod, R-I-Q, I think that's right. Q, is it Q or G? Q. Yeah, Q-U-E-S. And S-H, S-C-H, C-H-R-A-M-E-K. And let's look up that right there. There we go, Rodriguez. I'm spelling something wrong. HRS, non-lawyer counsel, non-lawyer counsel, counselor, and SCHARER. I want to make sure that I'm actually looking at this right. Court case. It's not giving me anything. Is this an AI AI ghost or something? Court case. Case instead. Okay. All right. That's what I'm looking for right there. But this is all it is the Florida Supreme Court reviewed the role of a non-lawyer counselors employed by the Department of Health and Rehabilitation Services. Okay. Okay, well, this doesn't even apply to it. What the fuck? Is this guy an idiot? Holy crap. Lurking in. Well, thank you very much, Taz, for lurking in here. Huh. I mean, this is ridiculous. This doesn't even how does this case even apply to it? It doesn't. Okay, this is absolutely ridiculous. I think this guy must be an idiot and looked up wrong case law on this. Oh. Yeah, let me share my screen with you so you can sort of understand how stupid this is. Let me share this with you because I this was just a simple Google search, all right? A simple Google search of what they're claiming here, and fucking morons. So this right here is the simple Google search for it. It says the terms you provided appear to be unrelated to a single cohesive legal case. Instead, they reference a whole bunch of other stuff. And then I went to the Florida, and basically the court ultimately established that active formal attorney supervision was mandatory for all legal document preparation and court appearances. Like that's what this is. Conclusion, the committee believes that the promulgation of an opinion by the Supreme Court will lead to the legislative changes and funding increases that would make a new uniform statewide system for representation for HRS an effective tool in the state's effort to protect the children in Florida from further harm. That's all it says. Are there any new stories available? No, we don't have any new stories for Sunday Spies. Like the committee conclude the lack of legal representation of HRS causes harm to abused and neglected children in HRS's custody. So what in the ever-loving hell are they trying to cite here? Because this, I've got the right case here. It's advisory commission of opinion of non-lawyer counselor. I mean, this is the only court case that they could be talking about. What in the hell? Did they have AI write this? And also, thank you very much, Shane Thomas, for being here for months. Oh my gosh, Taz has also been here. Oh geez, I'm not trying to slack on you guys. I literally was not looking at chat, but thank you so much. Oh man, like, I hope nobody's been sending in super chats or anything, because usually I'll get a ding or something. If I didn't, I do apologize. So what in the hell is he going off about? The Lugo Rodriguez Schraman HRS non-lawyer counselor and Schreier described the province of Florida Supreme Court acting on a Florida bar petition, not as what in the hell are they talking about? These aren't even related. I mean, what the hell are they talking about? I'm confused. As I was like, something doesn't seem right here, because they're not citing the actual case. No, that's not what this was. Well, he's an idiot. Well, but he didn't write this. That's what he's saying. There's an attorney that supposedly wrote this for him. Try thank you very much, Espire. But I'm looking at this, and it's just wrong, because they don't describe anything about the court acting on a Florida bar petition in Lugo Rodriguez Schraman HRS non-lawyer counselor and Schreier. None of these. They're just throwing shit out there. The distinction between case management, merits, adjudication matters for voidness of purposes. The court, but so why are they throwing out a case that has nothing to do with this? Is he completely stupid? I mean, I guess I'm getting my answer right there, because it seems like it. A judgment void if entered by a court without subject matter jurisdiction. Well, I mean, now I'm curious what this one is, because, he wasn't right on the last one. Let's actually look and see what this is. Because, I mean, he's citing freaking case law that may not even exist. And this is for an appeal. What the fuck? I mean, the judicial redress on this appeal, whether final summary judge awarding unliquidated damages in favor of the plaintiff, and specialty solutions, district court of appeal, not final until time expires, a final motion for hearing, non-final. I mean, they appealed the order denying its motion to vacate the amended final judgment. That's all it is. I mean, did they not read any? Okay, I'm getting frustrated with these morons. This is the absolute worst document I've ever fucking read. Yes, BBB is completely stupid. My opinion, BBB, I'm not allowed to say that. I also think that he uses AI to make up citations. I mean, they're actual citations, but they don't say what they want them to say. Wow. I mean, wow. I mean, I'm blown away by incompetence, unintelligible, to name a few more. Well, thank you. Those were the words I was looking for. Thank you. Good job. Good job. And the bar chapter 7 procedure is the order exceeded that boundary. No, it didn't. Is void under rule 140B4, not merely erroneous. Okay. Let's see let's just look, because they're citing out this rule. What exactly is the rule that they're trying to cite here? And I do believe I already looked at this to see what it was cited, and they're misquoting it wrong again also there. Let's see. Oh, okay, that's stupid. It is because the order exceeded that boundary. No, you're an idiot. You're an absolute idiot. I mean, all of this is just stupid. Now, Deuce requests that the court vacate the order in full or at minimum narrow it to a neutral perspective directed that makes no UPL finding. They don't make a UPL finding. That's the problem. They don't make a UPL finding. The way that you have to understand the way that the judge words this is because Deuce was practicing unlicensed practice of law. They had to show that he was doing the bad thing. The bad thing was the unlicensed practice of law. That unlicensed practice of law is the only way that they can remove his emails from their court system. What a fucking dimwit. I really hope that the judge hammers home this crap right here. And from what I can tell, is Judge Grabe isn't on this case anymore. There's another judge that's handling the case. Probably got passed to him from this judge. And I don't know anything about this judge, the new judge that's on the case. Except that he was an attorney for quite some time. He's been in practice for 34 years, I think, something like that. The record does not show service of process or legally sufficient notice. Now, here's something that he might be able to stand behind, but here's where the service problem he's going to run into is because in his deposition, Scott Stark says that he helped in substance. The docket history shows that he sought limited appearances in form. The judge's order addressed the gap between those two things, legal activity without proper Florida authorization, and Bruce knew he needed permission to appear because he kept asking for a limited appearance. That means he knew he was not just some random guy in Massachusetts watching the case. If he was trying to appear, if he was helping draft pleadings, helping investigate claims, emailing the court, communicating with parties, then the court had every reason to address whether he was improperly participating without admission. Does that make sense? Because even Scott Stark said that he was helping with this case. He's going to have an uphill battle. I wonder if he told the attorney this, that all of this stuff was happening, and they're just trying to. It sounds to me like they're just trying to get the UPL removed because he got his ass handed to. Florida makes it clear that actual awareness of proceeding does not cure the absence of legally sufficient service or process. It doesn't matter. I mean, they don't have to serve you or anything. All they have to do is make a ruling on it and refer you to the Florida State Bar. They don't have to have a hearing on this outside of it. I believe Grabe retired. Well, that's good for him. Good for him that he retired. I hope he's doing better. Yeah, I mean, all of this is just wrong. I mean, it seems like sorry, but it looks like an idiot wrote this. Florida two-step personal jurisdiction analysis further supports basically vacating the order. No, it doesn't. Here's the thing. Deuce reached out to the court. He didn't copy Randy on it. He copied Saran Wrap on it. He copied the judge on it, copied Lynette on it, and started sending them orders of what they were supposed to be doing. I'm sure, even though Judge Grubb retired, he's got some pretty hefty notes on this right here. And it's probably not going to look too good for him. That might have been why he waited for 5 months before filing, hoping he would get a little bit of relief and the judge wouldn't remember his bad behavior in this. He believed, I don't know if that's what he believes, Wolfgang. Yeah, Scott Stark did testify on record. Personal jurisdiction may satisfy both Florida's long-arm constitutional due process, blah, blah. I'm scared to look at what they're filing in this. I'm afraid to look at what they're actually filing as their case law on this, because you notice they didn't cite any case law on any of that other stuff. Oh, you sent me some pictures, and let me tell you right now, Carol, my Facebook Messenger is messed up. So if you guys are like sending me messages on Facebook, I can see them. I just can't respond to any of them. I can't even give it a thumbs up because it wants some sort of verification. I don't understand Facebook. I guess because I'm not very smart, and I tell people this. Oh God, dude. So I hit the wrong key, and it just like changed the screen on me. I haven't figured it out. And it keeps asking for some sort of verification. I can't verify it. It wants my ID, which I'm not going to give it to Facebook. So I can't respond in Facebook Messenger at all. So if you guys are messaging me and I don't respond back to you, that's why, because it won't let me. It just will not let me respond in Facebook Messenger at all. I've tried everything that I can. It doesn't like me at all. It hates my guts. Breaks my heart. The record does not show either requirement was met. Ducey was not alleged to live in Florida, maintain an office in Florida. Of course, does not show either requirement. What? Due process. You see, they're going over due process stuff. They don't have to. There is no matter of due process on this. He doesn't need to. All of the evidence is right there. You emailed the fucking court. There's no defense against that. If you, okay. So I'm going to say this again as I'm reading through this. Their premise on this is the court found him guilty. The court did not find him guilty. What the court found is this constitutes as it can be considered as the bad thing. You know, firing a handgun into open crowd doesn't mean that you actually hurt anybody, but it constitutes this bad thing. That's why we're sending you there. They got the premise wrong. It's okay. You never have to respond. Well, thank you, Carol. No, I'm just letting you know that usually I'll give like a thumbs up to let you know I got it, but I'm never able to respond to it. It's horrible. It hates me. And thank you so much again for the $1.99 super chat. Twice over. I will check those out. Thank you. Substantial, not isolated activity. The record also does not show that Deuce was named as a party. No shit. Served with process. Don't need to worry about that. Served with a subpoena. Didn't need to. Served with an order to show cause. Don't need to do that either. None of this does the court need to do. Oh, God. All the court has to see is that you did the bad thing. They see you did the bad thing. They handle the bad thing. The way they handle the bad thing is by telling you, no more bad thing. We're referring this to the Florida Supreme Court, where the Florida Supreme Court, you will be served. You will be served with a subpoena. You will be served with a show of or show in order to show cause. You will also be brought before the court through recognized procedure. That's all of the stuff that will happen with the Florida Supreme Court. It's not going to happen here. It's not going to happen in this case. I see no reason why it should happen in this case ever. Okay. I feel better. The notice of evidentiary hearing does not show service on Ducey because you weren't invited to the party. The evidence was already there. There was no argument of what was happening. your client, or former client, I should say, was supposed to be there. She could have argued those particular problems that they were having. She could have mentioned it. But see, unfortunately, Deuce, according to Lynette, she was told by multiple attorneys not to show up to that hearing because she was in a bankruptcy hearing, a bankruptcy case. She was told by multiple attorneys. And guess who some of those multiple attorneys are that she names? Some of those multiple attorneys that she names would be you. At least you that she names told her not to show up to that. Oof. That's going to be a rough one to swallow, isn't it? It's going to be a rough one to swallow. I guess we'll see how this all works out for you, Deuce. You know, you could have been a contender. Could have been a contender, Bruce. But oh no, you had to go screw that up. The notice of certificate of service certifies a service only on my shell. Of course, it doesn't identify Deuce as a person served. Doesn't need to. Why? Because they're not trying you. They're clearing up their docket. They don't need to try you. All they need to do is clean up their docket and make sure that this bad behavior that you were exhibiting stops. So what they did is they looked at the court documents that you were filing and they made a ruling on that. Then they referred that to the Florida State Bar. They don't give two shits about who you are. They do know that you're an attorney because you signed it Deuce Manscan Escuela for mental competency hearing, maybe. That doesn't identify him as a person served. Don't need to. December 5th, email from Hale's counsel was not a portal service, was not a formal email service under Florida rules of general practice and judicial administration. No, it wasn't a subpoena. It wasn't a summons. You're absolutely right. It was not a show order to cause issued by the court. Bedford is instructive because in this case. No, it's not. Bedford is not instructive in this case. Certified mail actually, no, they don't have to. Do you not understand this, Deuce? Different rules in the state of Florida. And as much as you can sit here and try to argue this stuff, I'm pretty sure that the judge is going to just go, yeah, you don't understand. None of that stuff had to happen, Deuce. None of it. Jeez, man. Was insufficient personal jurisdiction. There was no personal jurisdiction. Actual knowledge of the suit. There was no suit. There was nothing. That's the thing. They referred you to the Florida Supreme Court for this. That's it. They barred you from communicating with the court anymore, which apparently you got that memo. You understood that pretty damn clearly because you stopped doing it. Because it seems like those emails stopped. You were holding yourself out as an attorney representing Lynette, and they told you to file it through the proper channels if you were going to file something with the court. But you weren't admitted in the state of Florida pro hoc vice. Matter of fact, you were fired by your client, according to you and according to her. For these reasons, the record doesn't show service of process. Don't need to. The order should be therefore be vacated. No, not at all. Not at all. The lack of notice adversarial hearing record further requires vacator. And he's going to argue the same thing over again. It must be vacated under civil procedure. He respectfully submits that the order must be vacated. Judgment order is void where the court lacked subject matter jurisdiction, lacked personal jurisdiction, or entered the court through proceedings that did not provide the due process protections of notice and opportunity to be heard, because the Supreme Court is the one that's going to be hearing it. See, you have to understand that that gets referred to the Supreme Court. So all of your argument, your 51 pages of arguing this shit is absolutely a waste of fucking ink and paper. The trees should be absolutely pissed off at you for filing this much bullshit. The record supports the relief under the grounds recognized in Torres. First, for the record, does not show the court acquired personal jurisdiction. They don't need to. Now, he wants to reopen the case just for the limited purpose of ruling on this motion. I think the judge's motion should be pretty damn straightforward. And I mean, this is just my opinion, because like I said, I'm not an attorney. Judge's order should be pretty straightforward and say, your motion is denied in whole. You're being referred to the Florida Supreme Court for UPL. They didn't, all they ruled on is that they were going to refer this to the Florida Supreme Court for them to make the ruling on what to do. Pissed off trees, mark your bingo cards. They recognize that deuce appears specially and solely. Well, of course they can do that. They could absolutely do that. Limited purpose of challenging the order without waiver or jurisdictional defense, without constituting a general appearance, which I think the court could do that. Vacating the order, which I don't think they will. And for sanctions, well, if I'm not mistaken, I'm looking here. What does it say? Engaged, he is enjoined from further and they're from further communications with the court, and actively participates in this matter, and identify the court all parties, the name of anyone that, oh yeah, that's amazing. That's all it says. I'm looking at this and I'm not seeing any sanctions on you on this. No, I'm looking. There's no money, no monetary here. To just admonish, ordered to identify. This is pretty straightforward. I mean, there doesn't look like they put sanctions on you. Interesting, isn't it? Do you not read the case, or did your ChatGPT not do it? Because right here you're saying that, sanctions for unauthorized practice of law, they have it. And for sanctions, there was no sanctions. I think they ran this through ChatGPT. They messed up. They ran this through some sort of AI to get this to spit out like this. This is horrible. Tonight, wrong court. Go F your memories of Gainesville to Gainesville. Yeah. He has, I know he does. Yeah, he has an attorney representing him. An alternative, vacate all findings that deuce engage. That's the problem. They didn't make any findings. They referred this to the Supreme Court. Your argument is not with this court. Your argument is with the Florida Supreme Court that's been referred to. I mean, I could be wrong. That's what it looks like to me, that this should be going, that this argument should be going to the Florida Supreme Court, because they would be the ones that would be in charge of sanctioning you and making the finding whether you've committed UPL, unlicensed practice of law. They would also be the ones that would be able to, handle all of the striking of any of the, unlicensed practice of law, because they're the ones that make the finding. That's why it was referred to them. Hey, my New Zealand friend, good to see you. The alternative, vacating all findings that deuce engaged and authorized, vacate all findings that they didn't make any findings, committed or engaged in the conduct characterized as felony. But you did. And they can characterize it like that because that's the only way they can find enough to send it to the Florida Supreme Court. Limiting any relief to neutral perspective directing regarding future filings or communications. Limiting any relief. Well, I understand what he's looking for. He doesn't want to be notified every time something happens in the case, which makes sense. Just on the limited part of what needs to happen in the case, like as far as he's concerned. Staying or suspending enforcement of the order while this motion is pending. Well, staying or suspending the enforcement, staying or suspending there is nothing. There is nothing to do. The court right here is saying that she's ordered to identify the court and all parties in the name of anyone not licensed to practice law in Florida has not been admitted pro hoc vice this court, who gives legal advice to her in matters before this court or drafts paperwork on her behalf, which is submitted to the court. There's no reason for them to put a stay on that. There's no reason for that. That would be like saying, well, we'll let you continue emailing us to the breaking the law and practicing licensed practice of law in court. Confirming the court makes no finding the civil action that Deuce has committed. I certify this conferral prior to filing is not required under this, which is true. You don't have to confer prior to filing this particular one. I mean, under those rules, I mean, you would have to under other certain rules because, the motion that he's pleading, it doesn't say that that's an exception, but I think that they'll just let it pass. But this is where we get into the meaty stuff of his absolute garbage here, which is hilarious. Motion to strike unauthorized communications and for practice of law. I'm looking down here. It gives the factual background that what do you read? What are we reading here? So this is just a motion to strike. So this was brought by Jeremy Hales. This isn't the order. Okay. So this isn't the order. Okay. I'm looking through this and all it was just a motion. We already know what the motion is. Okay. So where's the order? Where's the order? Why are they putting this in here? I'm curious. Why? Okay, let's see if we can find a Exhibit A in here. Copy, and I'll just do a quick search because I'm looking to see what they're referring to in Exhibit A. Why would you put an exhibit here and not list what the exhibits are in your case? Okay. Let's see. Exhibit. All right, let's see. This is it. This is the first one. That's the only exhibit we got. Okay, that's really weird. Okay, this makes no sense. Okay, so this is really, really bad. This is absolutely really bad. Oh, I'm sorry. It's another. Okay. Usually, whenever you put exhibits into a pleading, any sort of pleading, whenever you're referencing these exhibits, those particular exhibits have something in the body of the motion that you're making that says Exhibit A and tells you what Exhibit A is. This doesn't do that. Like, it's just randomly thrown in there. There's nothing that links it to this. It's like throwing a whole bunch of shit out there. So in 15 pages, we got 15 pages of that, and then we've got a bunch of shit thrown at the wall. That makes no sense. Like, why is this here? I really hope that the judge looks at this and goes, okay, I don't understand what Exhibit A is supposed to be. It looks like a motion, but that motion was already filed. You don't have the order in here, which the order clearly doesn't say what you think it says. Tug just simply took a Sunday off to be with his girls. Yeah, that's what all Tug did. He does that every so often. See what sticks? Well, that's the problem. There's nothing here to stick. It actually hurts him really bad because all this is emotion. It's not the order. As you can see, this right here is the order granting the motion to strike. This is just a motion to strike and for sanctions. That's all this is. You have to go off of what the order says. See what it says. It came before it. It says the defendant's motion is granted. It finds that it's not, but it didn't provide any sort of sanctions. I mean, unless you want to say the sanction was that they're referring it over to the Florida Supreme Court. Will he be in trouble for writing for JC2? Depends. It really depends. As far as I know, he didn't write anything in this case for it because this was Lynette. Like the only case that John Cook has been involved in with Deuce as his attorney is Fed 1. Like Deuce was his attorney in Fed 1. So, I mean, because Deuce was representing both Lynette and John Cook in Fed 1. A lot of people get this mistaken and thinking that he was only representing Lynette. And I've seen the original pleadings whenever he took up the case. We know that he was ghost writing beforehand, but whenever he actually took over the case and was formally entered in pro hoc vice, is whenever he put in there that he was going to be representing both John Crook and Lynette in that. So it's a criminal. Is it a criminal case or what? Well, and that's the thing. At this point, it's all it is a referral to the Florida Supreme Court. All right. And that's why I'm pulling this up, because what it is right here is it's saying that he's admonished for engaging. That's all it is. It's an admonishment for engaging in unauthorized practice of law without proper admission of Florida State Bar pro hoc vice admission in this case. It doesn't show any sanctions, doesn't say anything about jail time. He's just being admonished, and that it was going to be going to the Florida Supreme Court. Right here, as you can see, he's enjoined from further communications with the court until properly admitted pro hoc vice, pursuant to these rules, and associated with Florida counsel or actively participates in this matter. So it doesn't even say that it's doing the thing. That's the weird part about it. It just says that it constitutes unauthorized practice of law and it is a third-degree felony, but it's referable for prosecution to the Florida Supreme Court. Whether it was referred to the Florida Supreme Court, I don't know. It's a possibility that it was. And the thing is a lot of times courts don't communicate with one another, and that would be why Randy reached out to Connecticut and Massachusetts to have them look at it also. And they already made a determinations. The grievance committee made a determination, and they're referring it to the Florida, to the Connecticut State Bar. I know that happened. I mean, that's what their referral was for it. And because here's the thing. Randy isn't involved in this case with Deuce. It would be like, here's the thing. If I started emailing a judge, putting myself out there as an attorney, I would expect that judge going, this guy is an attorney. He's trying to file cases through this, and he's trying to represent himself as an attorney. That in turn, that the attorney, either one of the attorneys on that case would actually make that recommendation to the Florida State Bar, and the Florida State Bar could do something. You're late, got to start from go. It's really easy. It's really easy. Even after he has to be removed. Well, and see one thing you have to remember, Stacy, is they fired him. He wasn't released. They fired him. That's the important thing to remember. And a lot of people forget that that whenever the hearing was supposed to happen in the state of Florida, whenever that was supposed to be happening in the state of Florida in front of Judge Belitho, Deuce basically said, "I'm not showing up." Judge said, "You are showing up." He said, "No, I'm not showing up." And then he gave an excuse. The judge said, "I don't care. You're still showing up." And then he didn't show up anyway. And then the day, as soon as the judge was there, what he did is he filed a motion that morning, and basically showing that John Cook and Lynette Preston had fired him from representing them. That was in, and that I mean, I can always pull that up. That's pretty easy to find. I think is like Doc 114 or something like that. But yeah, that was that. So they say, because they also said he has to be released. Well, yeah, but I mean, it doesn't matter whether what they said or who said what. What it matters is what the court views, and that's one thing, that a big distinction. Like, I could say a million things, but if I'm filing something in court, depends on what the court is actually looking at, and I'm looking at is what the court would be seeing. See, you know, it's like you can say, well, yeah, they're sanctioning him here in this particular case. You could look at it and say, oh, they're totally sanctioning him. But that's not what this says. This is what the court document says. It's referable for prosecution of Florida Supreme Court. It doesn't say that they're prosecuting him. See, and those are the big differences in a lot of this. Connections. Try your wano. I don't know what that means. Good night, Colleen. You have a good one. Actually, only 3 different accounts, because MLP said he was still their attorney even after BBB said he had been released and fired. Well, and you know, I know that's, well, see, that's the thing. We know all of that is true. We know that he was still working behind the scenes to continue to write motions. We already know this. That was an admission made by him that he was planning on doing that. We all know that, but you have to be able to prove this in a court of law, which is completely different. You can say 100 million things, but it's being proven in a court of law is where it matters. And that's why I'm saying, whenever the judge looks at this, if he reads what the actual order is and not what the motion is, because the motion is completely different. So he's arguing a motion. He's not arguing the actual order. The order is this. The motion is what they attached. Not really bright. Yeah, because they're trying to argue all of these cases right here, which doesn't do them any good. The court already adjudicated it and said, this is what we're finding. And then, of course, right here, sorry, you thought you misunderstood the reference to the bankruptcy reinstatement motion that is being heard tomorrow, because if Ms. Preston's bankruptcy is instated, all the proceedings before Judge Grove would be stayed. Well, and see, that doesn't matter, because she got that, and she was like, all proposed orders from attorneys must be submitted through the e-portal, or attorneys must submit via the e-portal notice of hearing, send a judicial assistant a copy. And he's saying, well, but here, Northern District of Florida Bankruptcy Court. She's like, kindly provide the case number so I can reference it accordingly. And what isn't it being heard tomorrow? Isn't it a video conference hearing? And of course, you know, she's just like, the bankruptcy is being reinstated. Thus, the 2 cases involving that. I note that Shaka's proposed order, but you also have to understand that he never attached any of this with Randy Shaka being attached to it. He just went out, emailed Candace, emailed Jerome Saran Wrap and then emailed Lynette and never emailed this to Shockett. Preston filed an MPO the day before. So he's trying to hear the case, trying to decide the case. And she's just like, this case is not scheduled before Judge Grubb. That's what she's telling him. It's not in front of Judge Grubb. And then, of course, more of their bullshit. And basically, Deuce is saying, Miss Pope, Miss Thomas, Judge Grubb asked for an order denying the MPO, not awarding sanctions for making any finding of fact, blah, 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 blah. Like, you can see him just absolutely going off on this. And then, of course, right here, he's saying, I can't believe you're unable to do something to make sure the judge sees what's happening. You got to see what's happening. Why isn't he seeing what's happening? BBB has been done and dusted. Suck it up, little man. Thank you, Rama. That's good. Oh, my God. After I was sacked, they still played me for 3 months because I answered a phone call after hours. Jeez. Let's say BBB did not get dragged into Fed 2. BBB could not automatically assume the role of representation. He would need to apply for a new ad hoc VJ or amend his current to represent LP. It's not ad hoc VJ, it's pro hoc VJ. If he did get dragged, well, see, he's not in Fed 2 anymore. See, here's the beautiful thing of it. A lot of people get confused on this, but the thing is Deuce is not in Fed 2 anymore. Fed 2, there's only 2 parties that are involved in Fed 2. That would be Lynette Preston and Paint Chip. Those are the only 2 that are involved in Fed 2. The judge took Randy's motion, which Randy's motion was to have the rest of them removed. He narrowed down what the judge asked him to do, narrowed down the people that they're going to pursue in Fed 2 to Paint Chip, Lynette Preston. And then changed what they were going to actually do. Might as well get as much as you can get done, narrow it down. Now the judge could easily come back and say, yeah, I'm going to find, we're just going to dismiss all of this, which he could. The judge could easily dismiss those 2 easily, any point in time. But the problem is Paint Chip still hasn't filed the proper shit. He keeps filing dumb shit. And the judge was like, you need to file the correct motions. Well, he hasn't done that because he wants to prolong it just as long as he possibly can, because who else is going to pay attention to him anymore? Because, nobody else seems to pay attention except for J-Hip. J-Hip pays attention to him like, just like I don't know. I think it's because Paint Chip is the only one that like really crushed on him like a man. Just like, I think J-Hip likes that man crush. It just excites his little body, gets him all like, and gives him the little wiggles, makes him feel happy. Now they want a new Zoom depot contend to broadcast on YouTube to mock and humiliate her. That has nothing to do with this. That's something you have to prove. Here's the beautiful part about this. We can mock and humiliate anybody we want to. We can mock anybody we want to. There is nothing illegal with mocking people for doing stupid shit. You have to understand, in thumbnail case, trespass case, those cases were brought by Lynette through counsel. Well, I think she initially filed it and then she hired counsel, according to the legal paperwork. Now, we know what happened in Fed 1 and Fed 2. Fed 1 got stayed because of the bankruptcy. Fed 2 got stayed because of the bankruptcy for Lynette. But that doesn't mean that the Paint Chip's going to get out of it. You're trying to hide something by not sending me my own files? It could be. BB is not allowed to shop lawyers for LP. That's true. Well, and that was admitted by I believe Scott Stark in that particular one, because he wasn't sure how she came about finding him. But we also have on recording where he admits to shopping around and looking for attorneys. He was constantly trying to find an attorney for her to represent her in the thumbnail and trespass case. He was also trying to find somebody to represent her in Fed 1, and he couldn't find any takers for that. I sort of feel bad for the attorney that got wrangled into this, because this is a really shitty filing, and absolutely, like, it's garbage. Oh, here they go. And this is the worst part about it. Here, let me show you. Then they put this order granting motion for judicial default. This has nothing to do with this case. This is Michelle Preston. Why is he showing this right here? Like this, I think this is one of Bruce's filings, because there's no reason for this to be in here. Like, if a judge looks at this, it's going to go, okay, this is a different case. You can tell by the case number, it's completely different. Teresa and Brett Granger, what is that? What do they have to do with this? They're plaintiffs in another case. Like, what's the point? Stupid. Okay, we're going down through here. And then, of course, Brett Granger. This is another case altogether, so a completely different case. And why are they throwing all this shit in here? I'm looking at it. What does this have to do with anything? Okay. Motion to set aside. This is Brett Granger. And also this case is already been it's already been handled. Applies to private and public. You have the rights to read them and correct them. There you go. I mean, Exhibit B, there's no listing for Exhibit B in any of this. Okay, this is Michelle Preston. Okay, notice of evidentiary hearing. Okay, what does this link to? Like there's nothing in there except for you're just throwing Exhibit C. More shit. Okay, so it shows that on December 5th, there was an attached motion and notice of hearing sent by Judge Grubb in this matter. Yeah, there's a motion, notice of hearing. That's it. So let's see. That was 12. Let's see. There was a notice of hearing in person. Yeah, there was a notice of hearing, a motion to strike UPL sanctions PDF. So that'd be 102, 103, because, I mean, they already showed what the motion was, but what was the notice of hearing? Pretty sure that the notice of hearing was pretty straightforward. If you didn't show up, that's sort of on you. You were notified. You were involved in this case. I mean, sucks to be you. And then, of course, this one right here, order granting motion to strike. Yeah. Okay. So now we get down to what the actual order was in this case. And let's see, he engaged in there, and it's a felony. Basically the same thing that I showed you. Okay. So that's it. That's all he's got. Like, did I'm sorry, I'm confused. Maybe did it seem like he gave a good case in there? I mean, I'll let you guys decide on that one. Do you think it was a good one? Do you think it was solid? I can't afford a lawyer. They knew I was an alcoholic for years. They let it slide. Ooh. Maybe these are examples of BBB ghostwriting for Elemental P. I don't know. I don't know. Like I don't see any case that he made in all of this. I mean, he pled a bunch of stuff that wasn't even part of this case. I mean, you have to. He's under the assumption that the court is sanctioning him. All the court did was, as far as I know, they're making a referral to the Florida Supreme Court. The Florida Supreme Court will be the one that adjudicates it, makes the decision. They could easily come back and say, yeah, I mean, it was bad, but we don't care. We just won't let him practice in the state of Florida anymore. Ever. They could easily come back and say that. I don't know how they're going to rule. That's Florida Supreme Court. That's their job, not this court. So, I mean, whenever he's screaming at the court going, you need to throw this out. No, the court don't have to do shit that you want it to do. Of course, you know, he'll argue that till the day he retires. Does Randy have to respond? I don't know what Randy would have to respond to. I mean, he could. Randy could easily respond to this, but I don't know why he would need to. I mean, he's basically petitioning the court to throw stuff out. I would hope that Randy responds, you know, to the motion that he's making. I hope Randy comes back and responds and says, Your Honor, everything that he's arguing is nothing to do with this case or his unlicensed practice of law or a notification or any of it. Like he was notified. He's been clearly notified, and he's been involved in this case for quite some time. He's been involved in this case before it ever was a case. He's been involved with Lynette Preston before this case was even brought. He is the one that brought this case. He is the one that went after Larry Foreman. He is the one that's trying to sue Larry Foreman. He's the one that came after me. He's the one that came after my family. He's the one that came after Jeremy, came after Jeremy's family. This is the guy that's harassed people online constantly. He's sent emails to people that are not attorneys, trying to dox them. I mean, this guy's bad behavior just goes on and on and on and on and on and on and on. But as far as the court of law, all he has to do is say, this guy doesn't know what he's talking about. None of this stuff makes any sense. Shit case if he is responding to the claim that he was practicing without a license. All the other documents in the case is a case Grubb ruled on already. Exactly. And Grubb was just like, you know, hell, this is what it is. No, you don't. We don't have to hear you. Like, there's no evidence for you to present. The evidence is right there. I mean, you're going to try to say that this case, that you didn't send these emails, somebody else sent them, when clearly you did. And the court told you to stop sending us emails, file it through the proper channels, and you didn't. I mean, I'm sure that they'll call Candace Thomas in. If there is an actual hearing on this, which I wouldn't be surprised if they end up having one over it. Then that judge isn't going to be too happy. Especially whenever Randy sits there and says, Your Honor, I mean, this is his behavior. This is what he does. He reaches out to courts and emails them and starts harassing them whenever he doesn't get his way and stomps his feet like a little bitty bitch. Of course, Randy probably would say that. Randy seems like he's too nice for that. He brought the case unofficially through his puppet Stark. Yeah. That's my thoughts. That's my opinion on it. I think that he did. We have admissions of crazy, screwed up things that he did, but you know that's neither here nor there. You know, that's going to be his little argument. Well, his little argument sucks. I mean, that was just poorly filed. That was really poorly written, poorly filed, and misquoted the law altogether wrong. Oh God. Oh, I mean, they were citing real cases, but real cases that had nothing to do with what was going on in this. Because I'm just like, what the fuck? It took me a few reads to sort of get through a lot of that. Sorry. Ooh, I'm sorry I had to make you suffer through that like I did. But I at least you feel my pain whenever I'm reading court documents. I mean, like I said, I'm not an attorney, but to me it looks like shit. It looks like absolute garbage. Like, are you really fucking kidding me that you were that crappy of it? I mean, so here's the thing. You know, just give you a nice little summary of all of this. He waited for about 5 months after the order was entered to seek any relief. And well, if the order were truly void, the 1.54B4 may allow a challenge at any time. That's if it were truly void. But if the order is merely alleged to be overbroad, imprecise, or legally erroneous, well, that delay really matters because The record shows that he was served with the order by email and mail, and his motion admits that he had been emailed the motion and hearing notice before the hearing. So the timing suggests the motion is less about lack of notice and more about just collateral consequences. And that's really what it boils down to. Oh, BBB did not want to write, but Your Honor, Randy Shockey, why can't you see my side? Hey, C. Dennis, how you doing? Oh, Bruce quit in chart. Then he tells the judge that he was fired. Yeah, Deuce quit in the chat. Of course, we know that he quit in chat. That's how he operates. Like I said, what you have to show is what happens in the courtroom or in court documents. You can claim all the other stuff you want to, but it's not provable in court. It's like the same shit that the flea is trying to do. So that's why I'm laughing whenever she's like, "Oh, I'm gonna sue for what? File it, fatty. File a suit. Seriously, file your fucking suit. Like, go for it." I mean, we're all interested in seeing what this suit is going to say. I'm sure it'll be a laugh riot. Positive that a lot of people are going to go, "What in the hell did she just? What is she out of her damn mind? She filed that?" I mean, there's going to be attorneys even looking at her stupid filings and going, "Wow." I mean, I thought I saw some stupid stuff, but man, that one really takes the cake. I like this thing has some rubber bands on it. I'm getting them all set up. It's pretty cool. They still won't send you a copy with your 26 years with 2 under subcontractor. So he says, advise employment courts of New Zealand, etc. Yeah, good luck. Good luck with that. It's crazy. That's right. Make us suffer with you. Yes. At least someone's suffering with me. Someone is suffering with me. But other than that, how have you guys been doing this weekend? I've had a good weekend. I've had a really good weekend. This reading through this document, because I was reading through it today, and I was like, I think I need a little help with this. Help me make sense of it. And yeah, once I read through it like the 4th or 5th time, I was just like, let me pull up some of this right here and do some simple Google searches and see what they're talking about here. And once I started Google searching, I was like, oh, this is bad. Like, this is really bad. I was like, this is like, this case law doesn't even match up with what they're trying to say. I mean, about the only thing that he might be able to get is the thing on service, but they're not, all they've done is referred it to the Florida Supreme Court. Maybe. I don't even know if that's happened, but I'm pretty sure that that's what Randy used to show to Connecticut and possibly Massachusetts. I mean, I don't know. Randy could have done anything he wanted to. I mean, they reserve jurisdiction over him. Florida's jurisdiction is just that he was practicing unlicensed practice of law. I mean, I would assume that Florida's probably doing something too. They're probably looking at it, but that's who he needs to take the case up with. I wonder when that hearing is going to be. I mean, I guess we'll find out about it soon enough. Can we see squat bug dancing? You want to see squirt? You want to see the squirt bug dancing? Let me see. I think I can arrange that for you. Yeah, we can make the squirt bug dance for you. that make you happy? That make you happy, Elfie? You like the squirt bug whenever it's dancing? I like the squirt bug too. It brings a lot of joy to my heart. I stopped nicotine sticks, $40 per pack. Ooh, pack of 20s. That's right. That's right. Because in New Zealand, Australia, I think they have 20 of those sticks in a pack. I remember I dated this girl way back that was from yeah, she was from Australia. I wanted to say New Zealand, but I mean she was originally from Australia, lived in New Zealand for a period of time, and then moved to the States. It was a nanny, I think, is what she was doing. Like, we didn't talk about work. That's not what our relationship was about. But whenever she showed up, she had like the big old pack of cigarettes. I was like, what the hell? They were just like, they were like 20 cigarettes in a pack or something. I was like, good Lord almighty. But yeah, that was some crazy times. Oh my gosh. You out of here, Twaddlebum? You have a good one, Twaddlebum. I wanted to see if I could wanted to show you guys something. You know what? I'll tell you what. I'll give you a little bit of the stinky poo. How's that? Because that one is I'm loving it. I'm having such a good time with that song. You realize that is an absolute hilarious song. It puts a big smile on my face every time that I see it. Yes, love the bug. Good morning, Shizzy. Mods and chat. Yes, but you don't have to read your comments. Oh, but you don't have to. Here we go. Oh, yes. So glorious.
Hey Travis, look at me. I've been watching you walk by. Got the big boss energy. Got me feeling stupid high. If you need somebody close, I can be that kind of guy. I can carry all your stuff. I can flatter you all night. Yeah, I'll be there. I won't move. I'll say anything for you. If you want a man right here, baby, I could be that fool. I'll be your stinky poo, stinky poo. I'll be your stinky poo, stinky poo. I'll do anything you want me to. What are you waiting for? Hey, I'll be your stinky poo, stinky poo. I'll be your stinky poo, stinky poo. I'll be right here acting desperate too. What are you waiting for? Hey Travis, pick me please. I can play the loyal man. I can laugh before you joke. I can clap before I can. I can tell you you're the king. I can kiss your heavy hand. If you want a shadow near, I can be your
Love it.
biggest fan. I'll be soft, I love proof. I keep all my eyes on you. If you want a man too big, baby, I was born to lose. I'll be your stinky poo, stinky poo. I'll be your stinky poo, stinky poo. I'll do anything you want me to. What are you waiting for? I'll be your stinky poo, stinky poo. I'll be your stinky poo, stinky poo. I'll be right here acting desperate too. What are you waiting for? Say the word, I'm at your feet. Call me up, I'm in the street. Tell me jump, I'll ask you how. Tell me later, tell me now. You want devotion, you want praise. You want somebody trained. You want a yes man on a leash. And baby, I'm ashamed. I'll be your stinky poo, stinky poo. I'll be your stinky poo, stinky poo.
awesome. Love this. And you guys, I'm going to be sending you over to Traveling Fools. I was going to send you over to Aussie Overlord. He was on, but I saw that he ended just as I was getting ready to do it. You guys go over, show some love to Traveling Fools. Give him some love. He's got a good crowd over there, and they're doing some trivia tonight. No drama, just trivia. Gotta love it. You guys have a beautiful one.